virus. Question 7, what are my remedies if the other party refuses to mediate? Well, if the other party refuses to mediate, there's a court procedure, and the information is there. But I think those instances are very unusual, so I won't go into any more than that. And 8 talks about the procedure for the court. Basically, it's just a decision on a motion, no witnesses or live testimony. Question 9, may we recover our legal fees and costs for the mediation? Generally, no, but possibly at the end of the case, if your documents permit it or don't prohibit it. 10, are mediation subsidized by the Condominium Education Trust Fund? And the answer to that is yes. And the reason why this is so significant is that mediations can be very expensive for both parties. And $1,000 if you're a homeowner is a lot of money to pay for mediation. The mediation service that we're discussing here provides that if the mediation is covered under this section, each party has to pay $375 to the mediator. And assuming that the mediator's charges are reasonable, the Condominium Education Trust Fund will pay not more than $3,000 of the cost of the mediation. So that's a pretty amazing deal if you think about it. And the reason why this is significant is that with a subsidized mediation, although there's a very good agency called the Mediation Center of the Pacific, which does very inexpensive mediations for evaluative mediation or mediation of complicated issues, you are going to be better off before an agency that handles commercial dispute resolution. But the dispute resolution agency is going to have retired judges or very experienced attorneys who charge in the range of $450 an hour and up. And so the cost of mediation, although it's much less than litigation, it's a significant expense. And so this is a huge benefit that the state is providing to condominium owners and directors and other people involved to try to get disputes resolved effectively with really good quality mediators. So question 11. What if there is ongoing litigation or arbitration? Can I still demand mediation? Yes, and you would have to request permission from the court or arbitrator. But I think unless there's some ulterior motive involved, that would be looked upon favorably. So the next section is on voluntary binding arbitration. This is a new section. It's the one I talked about earlier. And question 1, are arbitration subsidized by the Condominium Education Trust Fund? And again, yes, under this new law. It has to be for voluntary binding arbitration. So some documents, some of your declarations include a binding mandatory arbitration, and I'm not sure whether that would be covered. That's pretty rare, but it does exist. But if you have conventional documents that don't require arbitration, if the parties can agree to this binding arbitration, which means that the arbitrator's decision is going to be binding on the parties, they can't appeal it, then you may fall in this special program. So question 2, what kinds of arbitrations will be subsidized? So the arbitration must be voluntary, the arbitration must be binding, and you have to first have attempted evaluative mediation. That's what I was referring to earlier. So if you happen to request mediation and you don't specify evaluative mediation, when you get to the arbitration stage, they're going to find that the arbitration, the real estate commission, condominium education trust fund, is going to say that the mediation is not covered under this subsidized arbitration program, and it's going to be too late. So that's sort of a trap for the unwary. You need to specify evaluative mediation. And 3, what are the requirements for subsidized arbitrations? Your arbitration will be subsidized only if these conditions apply. Each party has to pay a fee of $175 to the arbitrator. But unlike the mediation program, which is limited to $3,000, the arbitration will be funded up to $6,000. And that's in part because arbitrations are much more time-consuming and complicated procedures. And it can include some issues that are extraneous to the ones that were required to qualify for mediation and arbitration. And as I said, there's an existing statute on non-binding arbitration, and so I'm not going to talk about that, but that's in the materials. So the other part of what I wanted to talk about is trying to deal with differences in community associations. And I put some information on pages 6 and 7 of my materials. I wanted to say that the condominium associations are very complicated entities and legal structures. Sometimes it's vexing to try to sort through all of the competing provisions. But when it comes to the people within the associations, I think that for a number of reasons, I think that condominiums are to problems as Petri dishes are to bacteria. And I say that acknowledging that the benefits of condominiums are immense. But there are some characteristics of condos that lead to disputes. First of all, condo associations are essentially limited partnerships where strangers who know nothing about their neighbors have to enter into a partnership and stakeholder with complete strangers in a multi-million-dollar enterprise. And although sometimes there are financial investments, for most people, they are where they live. It's where people bring their families and friends, and a home is where people are emotionally invested. And also people put their life savings into condos. It's a place that they have to meet their emotional and human needs for security, economic well-being, sense of belonging, recognition, and control over one's life. So when these needs conflict with the needs of other people, which they're inevitably going to do, there will be disputes. And, in a condo project, the association will own almost everything in the project except for the small things that are part of the apartment, which is primarily airspace and the finished surfaces of the walls, floors, and ceilings, and some fixtures. Everything else is a common element or limited common element. And as an owner in an apartment, in a condo project, you are a common you have a common interest in all of these assets that are common elements, along with everyone else. It may be a minuscule amount, less than a percentage on a big project, but you are an owner, and so it's a very complicated situation. So these comments that I'm making are really ones that were developed from my own experience, but they're validated by a couple of books that I've listed on the front section under the left sidebar under resources. There are a couple of books, Beyond Reason, Using Emotions as You Negotiate, and Getting to Yes. And these two books come out of the Harvard Negotiation Project, which started in the 1970s at Harvard Law School. And although they sound a lot like psychology, they come from the law school and are based on actual experiences growing out of primarily international negotiations. So here are my tips on trying to resolve differences or trying to live with differences in maybe a better way. So tip one is to consider core values. And before I go to negotiations, I'll often pull out my list of these core values to refresh my memory and to think about how I can address these things. This is just a practical list, and it's on page 7 of my materials. There are 5 of them, and the Beyond Reason book is all about these 5 core values, and they're values that you have as a negotiator for yourself, whether you're an owner or a director of the association or holding some other capacity, and also values that you're trying to address in the other side. So the first one is appreciation. Feeling unappreciated puts people down. We can appreciate others by understanding their point of view, finding merit in what they think. So even if you don't disagree with the other side, try to express appreciation of that person. Second is affiliation. Affiliation is easy in a condo association. Condominium associations, another name for that is common interest association. So just by becoming a member of an association, you have a common interest with everyone legally because you're all owners of extremely expensive assets. But in addition to that, you're members of a community, and so everybody can have some affiliation, and what you want to do is to develop that. Third, core value, autonomy, recognizing that everyone wants freedom to make decisions. That's difficult to do in a condo association when you have hundreds of pages of documents that tell everybody what to do or what not to do. But within that structure, there is room to recognize people's autonomy, and that is something that is needs to be thought about. Fourth, status, whether the person is, I think recognizing what is the person's status, or what is the issue that person may be having in terms of their social status. And the fifth thing is role. What role are you playing? What role is the other side playing? I think the role when it's a dispute between an owner and an association, the owner's perception is that the association is this huge monolithic entity with a lot of power and control. And so I think people need to be attuned to that and to try to understand what the role is of the other person, and not to quash that role, to try to negotiate in a way that doesn't make that person feel like they're failing in that role. So the tip one is to think about these core values. Tip two, try to understand the other side's thinking. And this comes from the Getting to Yes book, which I read first read in law school over 3 decades ago, but it's still in publication, and it's still a very good book, updated. And what that book says about trying to understand the other side's thinking, it says this is not just useful activity that you can use to help solve the problem. The other side's thinking is the problem. Ultimately, conflicts lie not in objective reality, but in people's heads. Everyone brings their predispositions and beliefs to the table, and that can cause a lot of issues. Understanding what the other side's fears are and dealing with them is very important. Even if they're ill-founded, fears need to be dealt with, and the ability to see the situation as the other side sees it, as difficult as that is probably one of the most important skills that a negotiator can have. But understanding the other side requires a relationship with that other side. Because if you don't have a relationship, you can still, of course, find information these days on the internet, on things that can pop up on the internet. But for the most part, if you don't have a relationship, it's really hard to understand where the other side is coming from. Tip 3 is my last tip. Think about interests, not positions. And this is something that is totally, at least for me, counterintuitive, because I always think that people act out of self-interest, and disputes arise out of disputes over what people's interests are. But in fact, and this comes from getting to yes too, when people argue, if you ask why are they arguing, the answer will typically be a reaction to something, not a purpose or interest. And that's something that I have found in my practice, that a lot of disputes are over a reaction to something that somebody said or someone did. Disputes over, for example, not approving some alteration that someone wants to make or doesn't want to make. Sometimes the dispute is over just a refusal to follow a procedure because that person is reacting to something that happened in the past. And it's in everybody's interest, even the owner's interest, to follow the procedure. If your declaration says no whatever on the balcony, that's what the document says. There's no amount of negotiation that's going to be able to overcome that. So it's in the owner's interest to comply with the requirements because the board doesn't have any authority. But still, these disputes arise, I think, out of reactions to personal interactions or something else like that. And so I think, as I said, condominium projects are really environments where disputes are almost, automatically going to arise. But it's amazing to me how, for the most part, associations function well. And actually, when you look at the interests, if you look through your documents, I think owners and boards, associations will agree on 95% of those requirements because they benefit everybody. Everybody has a financial stake, emotional stake in the project, and it's those few issues that seem to take attention over everything else. And hopefully trying to follow these core values, trying to follow these tips will help you avoid mediation. Thank you.